And during this lockdown period, a lot of high net worth clients will be reflecting and thinking about their life and how it is going forward. And interest in moving to the US, I'm sure, is part of that picture. For the viewers, what's the state of play at the moment on US immigration? Has there been a shutdown, or are cases still moving through the system?
So really, to answer this question, we could look back at the entire administration since 2017. The Trump administration has made immigration a priority and really reducing immigration. So, and the president has used the authority he has under the Immigration and Nationality Act to limit those who can come into the United States. And we saw this with the Muslim ban, which then has been expanded to include Venezuela and North Korea, currently has 13 countries. And with the, as the coronavirus and its effects were developing in the United States, the president used this same section of law to have a Chinese travel ban. So there was the China travel ban, and that was expanded to include Iran, and then the Schengen area, and then very soon after the UK and Ireland. And those bans are based on physical location. They're not based on nationality, in that if you are British or Irish, but you haven't been in one of those areas that's subject to the ban, you can still travel to the United States. And there are also many exceptions to that. So, for example, spouses of U.S. citizens, parents of U.S. citizens, medical professionals. There are the ability to overcome that ban. There's also, recently we had the excitement of the president tweeting that he was going to stop all immigration. That evolved a few days later into a ban on immigrant visas, which is essentially green card holders. But in this particular case, it actually only includes those who have not yet entered with a green card, who are making their very first entry to the United States. So it's quite a limited ban, and that one is set to expire on June 22nd. The other bans are indefinite, so until they're lifted. So we'll have to see what happens with that. But you asked, so that aside, immigration is still moving along. We have in the United States, the Immigration Service is still operating. Interviews for in-person services have been suspended until at least June 4th. But things like most applications are submitted paper-based, and those are being approved. And in fact, we're finding that things that normally require interviews, like green cards for employment-based cases and biometrics for getting work permits, those are actually being waived, or they're using biometrics from their entry to the United States. So those in the U.S. are able to move forward with the process, and those who aren't yet in the U.S. may have a way to come in if they're able to travel and or overcome a bar.
Okay, so it's a better picture actually than many might assume. You discussed there the sort of geographical issues that people might have, but are there any nationalities likely to experience most difficulty with visas? I mean, what's the situation within embassies around issuing visas from a practical perspective?
So actually it is more of a practical issue for most people. So for example, Australians in Australia, they're not subject to any kind of travel ban, but right now getting a flight is an issue. But really, if they're trying to come in and get if they need a new visa, most embassies and consulates around the world have suspended non-essential visa interviews, consular services. So they're really concentrating on American citizen services. So passports for Americans that need to travel urgently is a priority. So that is the biggest issue right now. So as restrictions are lifted around the world, we can anticipate that consular services will again resume. However, we're going to have a backlog of several months at least, and it won't be the same situation where you will have hundreds of people coming into a waiting room. So I'm expecting that the visa application process will take longer, and perhaps again, maybe they'll waive in-person requirements for low-risk cases, renewals, things that maybe aren't worth having another body come into the consulate. But we have to wait and see on that.
Okay, and how should those arriving and starting to spend more time in the US manage compliance around their visa requirements?
So the biggest issue right now for those in the United States are maintaining status, because ESTA, which is most visitors from the UK, will come in visa-free. They don't have any status that they can extend with the Immigration Service. It's a 90-day period. And with that, that cannot normally be extended. There are the Customs and Border Protection can extend in certain medical circumstances, which they have now used for cases, even if the person themselves isn't affected or ill, you can extend your stay. Unemployment is a huge issue, so we're having very high numbers of people losing their positions, including people with visas. So there are going to be requirements on maintaining status. If you're not working, then maybe the person would need to change to a visitor, perhaps with the Immigration Service. They may need to leave. If they can't leave, then they would need to look at other options. Interestingly, we're also seeing a lot of marriages for people who may not have. Maybe it's spurred their love. So a lot of people are marrying their U.S. citizen partners, and in New York, they're actually doing remote weddings. But I have been told that it's very difficult to get an appointment. So again, oversubscribed. A lot of people trying to get these online appointments with the city hall, and there's a delay on that. So it's essential to keep your status. The Immigration Service has many ways to do that. Most of them involve a fee. The ESTA is the only one that you can do without a fee, but they're holding tight on that and not waiving that, because the Immigration Service is having their own financial issues.
And you've mentioned a number of the practical points about people getting visas at embassies and how that's going to change logistically, and also staffing at the government centres. But what do you envisage as a likely change to the immigration in the future as a result of this COVID crisis?
So it's nice kind of bringing us back to the beginning, and then really the priorities of this administration, where we have an election in November, and immigration has always been a very popular issue for this president. I think, win or lose, from November to January, when he leaves office, will be an opportunity to make some changes. So I fully expect that we will see more use of 212F, which is the barring different people and different classes of people from entry. And he's directing the agencies to review their practices and policies to make sure that they are in the best interest of U.S. workers. Again, also pre-COVID, but that came up in the immigrant ban in April. So I think that he'll do everything, and his office will prioritize limiting immigration and making it more difficult.
And for those less familiar with the sort of policy-making procedure in the US, I mean, what are the powers at different levels of government to change the rules
with immigration, a lot of it is based on the agency. So when I mentioned USCIS, the Immigration Service, CBP, Customs and Border Protection, the Department of Labor, the Department of State that issues visas, all of these are actually offices within the executive. So the president has a lot of authority to direct and to set the policies of the administration of those agencies. So things like whether how something is defined, if it's not defined regulatory or in a statute. So there's a lot of gray area in most laws, and I think this, again, being a priority, that's been something that they've prioritized. It gets challenged, and that's where we kind of get into your question of this separation of powers, because only Congress can change the laws. Congress actually also is the one that will control funding. So funding the agencies and the priorities of the agencies is through Congress. And then ultimately we have the Supreme Court. And for the last 3 years, we've seen the administration, the executive branch try to do something, and it get challenged and either affirmed or overturned by the courts. So the courts are playing a big role in making sure that each branch of government is kind of staying in its lane.
For those looking to move to the US with a solid business idea and the drive to scale it up, the E2 visa is an option that's well worth considering. The E2 visa is a non-immigrant temporary visa that is available between treaty countries in the United States. The Grenada Citizenship by Investment program is a popular route to obtaining the E2 visa. Mohammed, perhaps you could tell us more about the Grenada Citizenship by Investment program.
Yeah, thank you, David. So Grenada has had a citizenship program for approximately 2 decades now. And recently, in the last 12 to 15 months, has really catapulted up the ranks of second citizenship programs. It's enshrined in the legislation of the country. And in essence, an individual of good background, and there are some significant due diligence checks taken on that individual prior to awarding him or her citizenship, is able to obtain citizenship of Grenada within a 3-month period. Now, to obtain second citizenship of Grenada, that individual is required to make an investment in the island of a minimum value of $220,000 in an approved project on the lovely island of Grenada. And we are the leading developer in Grenada. In addition, there's a whole bunch of other government fees that individual is required to pay, depending on how many applicants or how many dependents are also applying with him. And thereafter, within a 3-month period, subject to all the checks coming out positive, that individual and their family become a citizen of the island of Grenada.
And what kind of investment opportunities do you offer these investors? If you explain a bit more about the sort of assets they can invest in. Sure.
So we've been active in the Caribbean since 2012, and in that time period, we've become the leading developer in this space. We opened the Park Hyatt St. Kitts in 2017 to reviews of Best New Hotel in the Caribbean from CNN. In the first year, in our debut year, we were in the Condé Nast Hot List, so we're very proud of our development in St. Kitts and Nevis. We also opened the Kempinski Dominica in 2019 to similar reviews. Wall Street Journal put that hotel on the bucket list for 2019. And we've recently embarked on the Six Senses development in the island of Grenada. We started construction in February of this year. Very shortly, thereafter, we had to be locked down like all other countries in the world. But we will be back on site in the coming 4 to 5 weeks. And that project will be completing at the end of 2022. It is a lovely resort spread over 24 acres, 100 rooms. It's approved for citizenship, so investors who invest the minimum amount according to statute, which is $220,000 US, get a investment it's a real estate investment trust structure. So you obtain ownership in the resort. You receive a yield along the way, and that investor has to keep his share as per statute for 5 years under the laws of Grenada, and thereafter he can sell his share to another individual who also wishes to obtain for citizenship, whilst he maintains his citizenship in perpetuity for the rest of his family.
Great. And are there any nationalities or regions of the world that you're finding most demand for the Grenada option?
So look, before I answer that, maybe let's look at the benefits of what a Grenada citizenship provides, and then we can see where the demand is coming from. So, historically, Caribbean citizenship has been a global mobility strategy. visa-free travel or hassle-free travel to 140 countries around the world, all of the large trading blocs, be it Schengen, the United Kingdom, China with Grenada, Russia, and Southeast Asia, as well as most of South America. However, over time, and especially with what's happening in the world today with the pandemic which is upon us, it has gone from a global mobility strategy to one of a migration strategy. And by that, I'm not saying individuals are looking to necessarily live in Grenada, although some are. It's not a bad place to hide out a pandemic. But Grenada, since 1983, has had a treaty of trade and commerce with the United States. And that's where its E2 visa reciprocity was memorialized. A little bit of a history lesson. The island was invaded in 1983 by Ronald Reagan at the end of the Cold War. They were building, certain people were building a very long runway in Grenada, which was causing anxiety to the United States. So they invaded the island. And as part of the reparations of the invasion, they were awarded the E2 visa treaty. Now, what does the E2 visa treaty say? It says if you invest in your own business in the United States, a minimum amount in excess of $100,000, you can apply for an E2 visa, which lets you invest and reside in the United States with your family. You have to run the business, your spouse can work anywhere, kids benefit from state education below 18, and reduced university fees subject to fulfilling residency requirements. So, David, for a number of individuals in the emerging markets, that is a very significant advantage. Now, historically, until 2016, I would arguably say the perfect way into the United States was through the EB-5 program, however, which is the green card program as it's colloquially known. However, at the end of last year, there were a number of significant changes to that program in that the price went up to 1.8 million. There are certain exceptions if you invest in an area of very high employment, where the investment threshold is 900,000, but you have to question the viability of investing in an area of significant high unemployment, especially in today's day. This is under the EB-5 program. And also the waiting list for individuals from China is 15 years, from Vietnam is 10 years, India is significant. So the minimum length of time it's going to take you to get an EB-5 is somewhere between 3 to 4 years. Now, with COVID upon us, individuals in the emerging markets are nervous. The West will recover. The West will recover first. Huge amounts of stimulus have gone into some of these economies. Take the UK, take the US. However, emerging market governments do not have the same tools to preserve their economies as some of their Western counterparts. So businessmen, entrepreneurs are worried about not just the viability of their businesses, but they're also worried about personal safety and security. You look at certain countries, South Africa, for instance, you have the president writing in the newspaper, requesting his citizens not to go to the streets and not to turn to crime. And people aren't turning to crime for any other reason apart from the fact they need food. In a number of emerging and frontier markets, whether you're looking at parts of West Africa, South Africa, the subcontinent and beyond, not only is there economic insecurity, we're also looking at personal insecurity. Those are the markets where we're seeing a lot of interest from. And, David, one other thing, put yourself in the mind of an expatriate entrepreneur, whether it's in the Gulf or Southeast Asia or somewhere else, and you're sitting there and your business has effectively halted, okay? Maybe you're a second generation entrepreneur in a country which isn't your own, and you're questioning whether it's worth restarting in that country, or whether there's been such a change in your economic circumstances, it makes sense to pick up and migrate and look at the E2 route to move into the United States and start afresh. So we're having conversations like that on a daily basis. As you mentioned first, India and China are not E2 countries. And hence EB-5 was very popular in those countries until the price went up and the waiting list really expanded to an unsatisfactory amount. And that's why people will do Grenada, become a citizen of a country which has a reciprocal E2 treaty, and then springboard into the United States.
What kind of business under the E2 visa can you set up? Are there limitations around the sector or industry?
Well, it's anything. it's your business. You're not investing in a fund. The law says it has to be significant, which isn't defined, but by custom, and it's adjudicated at the nearest US consulate to either where you live or to your country of citizenship. So that'll be Barbados or, wherever you're currently residing. And the accepted definition by custom is north of $100,000. You have to maintain or have the ability to direct and develop the business, which means something more than being a board member, but it doesn't mean making the coffee if you buy a coffee shop. And obviously, being on the board, hiring the staff, being active in terms of payments, that's typically sufficient, and you have to have a background in business, or you have to show you have an ability to run the business successfully. And there is no restrictions in terms of sector. So, David, you could set up PCB New York, put in a business plan, and that could be your E2 business. However, for a lot of people, let's say they're emanating out of an emerging market, they haven't spent some time in the States, we recognize it's difficult to identify the right business opportunities. And for those individuals, we recommend a franchise, where obviously the franchisor has done a lot of work. He's put together the policies, the procedures. So those sorts of structured franchise products could be also quite attractive.
But for the next generation in a family business, for example, it could be the children of a family business going to the US to try and make opportunities there. The logic is they're already, got a business model, but just trying to roll it out further. So that could be quite interesting as an opportunity in the absence of other ideas, I suppose.
Absolutely. And if you actually also look at the capital, let's take the example, you have a garment factory in Bangladesh, okay? You decide you wish to get into retail clothing in the US. Your capital investment in that business is not limited to cash. It can also be the garments. So ideally suited for family business looking to expand into the United States. And another thing which individuals are considering in this area of deglobalization, having a Grenada and a US residency with the E2 route allows you to be intertwined in the fabric of the United States where your customers are. And that is going to be something which is looked at positively, I think, in the post-COVID era.
And how long is the visa period, and what's the process around renewals and things like that?
So Grenada has a very flexible E2 visa treaty with the United States. And each country, or each of the 60 or 70 countries which have E2 visas, all have different nuances. So it's very important to look at this in detail. Grenada provides you with a 5-year, multiple entry, indefinitely renewable visa at 5-year stints. Other countries, there's only 2 other countries which have E2 visa treaties with the United States and also have citizenship by investment programs. Take Montenegro, for instance, that would only provide you with a 12-month E2 visa, which is not really that much use if you're considering migrating, and every 12 months you have to renew this visa. So Grenada provides you with a 5-year multiple entry, a renewable indefinite number of times. And in terms of renewals, it's an administrative process, and really they're looking to see if that business is still there. So in your example, David, if you're setting up PCD New York and you give them an address, you bet PCD New York has to be operating out of that address, and it'd be great if you employ a couple of Americans as well in that time. Obviously, a business plan is just that, and that's what you submit at the outset. Everyone recognizes businesses can go wrong and right as well. But the key thing is the business plan has to make sense or have a fighting chance of success.
And after the finished sort of involvement in the business, is there opportunity to convert this visa into something else, to step back, or do you think it's manage your involvement in the business is the way to make this a long-term option?
So look, there have been people in the United States on an E2 visa for 30 years. Okay, so it is, whilst it's a non-immigrant visa, as long as you fulfill the renewal requirements, you can maintain your position in the United States. Now, I think what's very interesting for your audience is there doesn't seem to have the same tax liabilities as permanent residence or citizenship of the United States. So if you don't pass the substantial presence test in the United States with your E2 visa, you're not taxed on your worldwide income, only your US sourced income. So at the simplest level, if you don't spend 122 days in the United States, and I appreciate that number can change plus or minus based on personal circumstances, but let's look at the general. So you don't spend 122 days in the United States. You will only be taxed on the income generated by your business in the United States. So for certain people, that is an ideal situation. So take again, going back to our garment manufacturer in India, that's where the bulk of the assets are. The wife and the children move to the United States for perceived or actual better quality of life or education or for whatever reason. And the main entrepreneur is backwards and forwards, and he spends less than 122 days in the United States. That suddenly becomes quite an interesting opportunity from a tax structuring perspective. Now, put onto that he's no longer an Indian, okay, and he has a Grenadian. He may even be able to obtain, and if he obtains his overseas citizen of Indian card, he may also be able not to fall into the ambit of Indian taxation as far as his overseas assets are concerned. So that's a strategy which really needs some delving into, but can have some great advantages. But in terms of answering your questions, once your business is up and running in the US, and if you are looking to change to permanent residency, there's a couple of the EB visas which might which you may be able to consider. First is the EB1, I think it's either A or C, whereby if you're managing a number of professionals or specialist individuals, you can change your E2 into that. Also, you can apply for an EB5, and once your EB5 petition ripens, okay, in terms of when your turn comes on the waiting list and your business grows to the minimum thresholds which are applicable at that time, a number of people look to structure it in that manner. But so I think it's important to identify what is your actual US strategy and what is your US ambition, and then we can work back from that together.
What are the classic mistakes that you see people immigrating to the US?
Yeah, well, I guess we start with what are my goals as a private client advisor when I have a client like this that comes to me, and hopefully, God willing, has come to me before they've got secured a green card, or well before they decide they want to come to the U.S. And my goal is to minimize U.S. taxes and really their global taxes. So work with their outside advisors in other relevant jurisdictions, their home jurisdictions, and say, take a holistic look at their structures and their assets, their income sources, and say, how can we lower their global tax bill, including once they come to the U.S. And the good news is there's a lot that we can do with these clients before they get to the U.S. to lower their U.S. tax bill. And we'll talk about that in a little bit. So the primary mistakes I see are that they haven't secured advice, whether it's from me or from another practitioner, before they come to the U.S. and start thinking about what they can do to get their affairs in order before they get here. Or if they actually have seen someone, they've forgotten about certain assets, they haven't identified all the income streams. They have other family members that might be coming that we didn't think about. We didn't look at kind of where they're domiciled in the world, where they're subject to tax. And because not only do we worry about the U.S. tax system, we worry about the other tax systems the family is dealing with. I think for some clients, especially I think in some of my Asian clients, Latin American clients, when they find out about some somewhat onerous nature of the U.S. tax system, they say, well, I'm just going to give my assets to my mother. And then I'm not going to worry about these issues. And then, of course, you worry about how that money's going back into the U.S. So I think some of it's education as well, and making sure they don't fall into that pitfall. But the good news is if you get the proper planning before you come to the U.S., you can drastically minimize your tax bill here in the U.S., both from an income tax perspective and from an estate and gift tax perspective, in a manner that would be almost unachievable once you got here.
Okay, terrific. And I mean, how would you describe or characterize the US tax system for someone arriving for the first time? How does the system look?
Sure. Well, if I'm counseling a client as to what the U.S. tax system will look like when they get here, I think that the thing that, it's not surprising to a lot of people in the industry because they know the U.S. has this, but for a lot of clients, understanding that when you're a U.S. income tax resident, you're taxed on a worldwide basis, that wherever you generate income in the world will be taxed in the United States, subject to treaties and things like that. That's a surprise to some clients. So we have an income tax system we have a number of tax systems in the U.S., but the ones of most relevance are really the income tax system, both federal, and we'll touch a little bit on state, and then the estate and gift tax regime. From income tax perspective, once you are fully income tax resident here, you're subject to income taxes on the income you generate. If it's ordinary income, it's basically it's a progressive system up to 37%. Capital gains are taxed at 20%. And for estate and gift tax, so the estate and gift tax regime, if not properly planned for, can be very onerous and very confiscatory of family wealth. The good news for people immigrating to the U.S., or there are things that we can do prior to them arriving in the U.S. to basically take assets out of their taxable estate and basically put them in trusts or other vehicles where those assets will never become subject to the U.S. estate and gift tax regime. But the estate and gift tax regime, it's effectively a 40% tax imposed when you die on the gross value of your assets. And if you're domiciled here for estate and gift tax perspective, it's a 40% tax on your worldwide assets and whatever you own. And there's a pretty healthy exemption. It's about a little above $11.5 million right now. And that was passed or increased under the Trump tax bill in 2017. But that exemption will go down to $5 million in 2026. So really, most of my clients are planning for it to be $5 million. And so for most of my clients, their wealth is well above that number. So we do some significant planning to basically get them out of paying that tax. But like I said, there's planning that we can do for people before they get to the U.S. that makes it much easier to take significant wealth and shelter it from the estate and gift tax system.
Okay, so on the income tax side, then, at what point do they become resident? Is the day count? How does that work in terms of number of days?
So from an income tax perspective, citizenship, if you get a passport, you're in the system. You proudly are going to be taxed on a worldwide basis forever, unless you expatriate. If you obtain a green card, same thing. As soon as you obtain your green card, on an income tax perspective, you're subject to worldwide taxation the moment you receive that green card. If you don't have a green card and you're not a citizen and you're just spending time in the U.S. on a visa, as you properly pointed out, David, it's a test based on day count. How much time are you spending in the United States? And it's a pretty objective test based on number of days. And so basically, in any given year, you have to spend at least 31 days in the United States for the year you want to test. So if you spend over 31 days or 31 or more days in a year, we look at that year. And then what we do, there's a calculation. And basically, if you're at 183 days or more present, based upon the calculation, you are income tax resident on a worldwide basis in the United States for that year. And basically, that test counts all the days of the current year, a third of the days in the year immediately prior, and then a sixth of the days of the year immediately prior to that, so the second prior year. And if you add up those days and it's 183 or more, then you're a fully income tax resident here in the United States for that year. You got to file a tax return and you've got to pay tax on a worldwide basis. There are exceptions. There's good exceptions to that rule. One's the closer connection exemption. So if you have a client who violated the state substantial presence test, so was over the number of days, but in the particular year was in the U.S. less than 183 days, you could basically file with the IRS a form that says, hey, even though I spent too many days in the U.S. that year, I have a closer connection to another country. And then you basically show the factors, whether your permanent residence is there, your doctors are there, your family's there. So don't treat me as a full U.S. income tax resident for that year. We have a lot of Canadians who use that exemption because they've spent a lot of time in Florida. They spend basically, if you look at the substantial presence test and you want to maximize the number of days in any year, you could basically spend 121 days in the U.S. every year. But we have Canadians and obviously other nationalities where they spend over 121 days, but less than 183. So they'll file this closer connection exemption. The other big exemption is for a treaty based. So basically, if under tax rules of one country in the U.S., someone's tax resident of both, and we happen to have a U.S. tax treaty, we can use that treaty and the tiebreaker rules to basically ascertain, well, really this person's a resident of France. And so then we file a treaty-based position with the IRS to make that clear.
Okay, and on the estate planning side then, at what point does an immigrant become subject to taxes on their estate?
That's much more subjective. It's based upon domicile. And so basically that's where they live and where they intend to remain. And so it's very much a facts and circumstances question. I have a number of clients that have green cards. In Asia in particular, it's kind of somewhat fashionable to obtain a green card, but they might not live here. And so we can take a position because they're not physically present here and they don't intend to, even though they probably should as part of the terms of their green card, intend to live here permanently, they don't. And so we can take a position for those folks that they're not subject to the U.S. estate and gift tax regime. But realistically, once you obtain a green card, you spend time here, you have a residence here, you're going to become domiciled in the U.S. for estate and gift tax purposes, meaning that you're going to be subject to that 40%, basically 40% tax when you die on your worldwide assets. The gift tax regime works as a corollary to the estate tax regime, making sure that you don't just gift away all your assets before you die, so you're left with nothing to pay estate tax on. And so those folks are subject to that regime as well.
And given that inevitability, I mean, is there planning that potential new arrivals do to minimise their exposure to U.S. taxes as a whole? Yeah. So what we do is, from an income tax perspective, the planning that we do, we really try and trigger gains. But what we want is, we don't want historic gains, pre-arrival gains, to be taxed in the U.S. So we try and implement planning to basically trigger those gains before that person arrives in the U.S. So those gains never get taxed here. Now, of course, that requires you to understand, okay, if they're not going to be taxed here, where are they going to be taxed? And could that actually be worse in the United States? But assuming that it's not worse, we want to trigger gains. And how we do that is, if they have securities, we can have them, if they're publicly traded, have them buy or sell a security and repurchase them immediately to trigger that gain before they come to the U.S. We can utilize what we call check the box elections in the U.S., where if they have assets held within the structure, we can effectively file a check the box election here in the United States for that entity and cause a deemed liquidation. So basically it's treated as if that company liquidates and it triggers gains. And at that point, the person's not in the United States. So unless those assets are U.S. situs, which we make sure they're not, they're non-U.S. situs assets. Even though we've liquidated that company, it's a deemed sale for U.S. tax purposes, but that tax won't be paid in the U.S. So we can do, and that's, of course, if they've got salary income or deferred compensation that we can get paid out before they come to the U.S., we'll encourage that. And on the other side, if they've got deductions or expenses that they're going to make, we want to postpone that until they come to the U.S. and get the benefit of those deductions. I guess there's some other things that we do. We look at their structures. If they've got foreign corporations, because we have pretty nasty CFC and PFIC, private passive foreign investment company rules that discourage Americans to hold and invest through foreign corporations. We'll look at their structures and say, before they get here, and get rid of foreign corporations to the extent we can create pass-throughs. So basically, they don't walk into a huge tax trap when they arrive. If they are beneficiaries of foreign trust, because some of the foreign trust rules we have, where you have U.S. beneficiaries, are pretty onerous. We try and fix those issues from an income tax perspective, because they could be in a situation that once they arrive here, they won't be able to benefit from a family trust because the distribution they receive would be eaten up entirely in U.S. tax. And then if they had PFICs, the passive foreign investment companies in that trust, it's quite possible they could end up owing tax over and above their distribution. So we fix those issues before they get here. And from an estate tax perspective, we'll do estate planning and using trust before they arrive in the U.S. So because they're not subject to the U.S. gift tax regime, we can transfer non-U.S. situs property into trust free of U.S. gift tax, put them into trusts that are estate tax proof
from the U.S. tax perspective. And so effectively get assets out of their estate on a very efficient, non-taxable basis in the U.S. before they arrive, to basically take those assets out of the U.S. estate and gift tax regime forever. Is something I've got domestic clients, it takes them a lifetime to do that planning, but we can do that within like weeks before they get here.
Okay, I mean, for someone moving to the US, often setting up a new business is part of the picture. It might be the next generation of a family whose children are coming to the US with the business idea. From the outside, there's a perception of the US being a very litigious place. So how would you work with those clients to minimize exposure and risk they're taking in setting up new ventures?
Sure, and it is a very litigious place. I can vouch for that, as can my litigators in my firm. But it's the good news is the business environment is very, very friendly here. There's an entrepreneurial spirit throughout the U.S. So that's the good news. It's very easy to establish a business here. I think the market's very receptive to new business ideas. And so I think that makes it a very attractive place. But you do have to, when you structure your business, you do need to do it properly, and litigation is always a risk, especially, depending upon the business line in question. I mean, if I'm setting up a retail clothing shop, I'm probably not worried about it as much as if I'm, investing, certainly if I'm a real estate developer, or if I'm raising capital from outside sources and I'm going to deploy that capital in some kind of fund structure. So with those types of business ideas, I'd be worried more about litigation. So the good news is, well, certainly we can get insurance here in the U.S. Very easy to get to basically insure against that type of risk. But for a lot of my clients who have asset protection concerns, there's a number of things that we can do for their business. So we'll put them in limited liability companies, properly structured. So we have the laws surrounding business entities, so long as you respect the substance and the structure, are very strong to protect. It's very difficult to protect the assets within your business, but once you pull the assets out, so long as you leave that business sufficiently capitalized, we can pull assets out and protect those from creditors and from other potential claims. And that's very easily done here in the U.S. And then, of course, we can use trust and other vehicles, which obviously many of the viewers here will be familiar with in other jurisdictions.
And for US entrepreneurs setting up the business, is onshore or offshore structuring, popular? Are there certain jurisdictions that come up? What do you find is a trend there? Sure.
I think if you're setting up businesses in the U.S., you're going to end up using domestic entities. So entities in a certain state or trusts in a certain state, just because the tax rules make it very difficult. You can probably set them up in a way that can be tax neutral, but you're not going to save taxes by using an offshore structure. But there's advantages to an offshore structure, though, that I'll discuss in a second. So, and when you're looking at a domestic jurisdiction to set up a business or set up a structure, a family structure, there's certain jurisdictions that as a practitioner I'd look to. Certainly Delaware, they've got the deepest and most well-regarded corporate and business entity law, trust law. But there's other jurisdictions that are kind of competing with Delaware, which would include, Wyoming, Nevada. So there's other ones that might make sense. I do have clients that do avail, U.S. clients that do avail of offshore jurisdictions for asset protection, because they have business interest offshore where it just makes sense to have an offshore structure. Maybe they're raising capital for offshore structure or offshore funds, so they'll want to use someplace like Cayman to pool capital on a tax efficient basis. But it's much harder to navigate, especially when you're talking about business interests, to navigate that. I do have U.S. clients that will use offshore trust for asset protection reasons, and I think that that's perfectly legitimate. I think it's the tax rules surrounding on how to set up those trusts can get complex. But again, my role and my goal in setting up a structure like that, where we're using a foreign trust, whether that's in Cayman, Jersey, Guernsey, Bermuda, is to make it tax efficient from a U.S. perspective. Okay, and on the property front, can new arrivals buy US property? Are there any restrictions? Are there any geographies where it's easier or more welcoming for people who are coming in? Everywhere is welcoming in the US, but it's very easy to buy property as a foreigner here. There's no restrictions. You can buy property. The question is, how long can you stay in the property during the year? And that's where Anastasia comes in. So there's certainly jurisdictions where it's more popular. Obviously, New York, Florida, the places where it's particularly nice to live, and places where there's a lot of large international communities. I think that the system to market and acquire real property is very efficient here in the U.S. I think developers are pretty keen to develop in areas they see as to be popular for both Americans and non-Americans looking for property. I think as a pure tax lawyer perspective, I think that I would pick jurisdictions that would have lower tax burdens. So when you look at New York City in particular, California, Illinois, Massachusetts, those are particularly high tax states. So your client needs to understand that if they're going to acquire property there and spend time there, that the property taxes are probably going to be extremely high. The conveyance costs are very high, and the income taxes over and above federal are very high. If they're going to work out of that jurisdiction. Whereas if you looked at a Florida or a Texas, it's relatively inexpensive. I mean, Florida and Texas have no income taxes, and their property taxes are pretty low. But most of my clients, when you want to go to places like New York or California, and so we structure to basically minimize those tax burdens to the extent we can.